is Mr. Who?
With the court's permission.
Mr. President,
Just hold on here, Senior Counsel.
No, it's on. With the court's permission, we actually had also caucused and we are pleading with the court.
Yes.
There are 6 of us. And we were 6 teams representing, there is Ongoya, whom you have mentioned, representing Justice and Isaac Ogola. There is Muhuri and Kituo cha Sheria, represented by Dr. Haminwa. There is Alucher in Pasco. There is Dr. Muimali, represented by Dudley. And there is the 3 Amishi, Ambani, Musumba, and Ojwang, represented by me and Mudhoni. And there is Kenya Human Rights. Oh, Kituo cha Sheria, I mistook the name. Dr. Haminwa represents Kenya Human Rights Commission and Kituo cha Sheria. We were pleading that you consider giving us a little more time than the half an hour. Those of us who will finish before, we will not take the court's time. And we appreciate the court's wish to finish this case today, and it still can be finished. We are just pleading that the court be flexible, even if it means sitting into the evening to finish the matter, but to help us to have enough time to ventilate. Because we are here as respondents and we need time to ventilate.
Senior Counsel, I appreciate what you say, but to remember the so-called night sittings have become an issue in our jurisprudence, and we may not be able to go beyond 6.
We've sat before. In the Hunduma case, we were sitting beyond 8, and in many other cases, we would plead with the court.
I wish you knew the issues that have risen out of those so-called night sittings.
It's more propaganda than real issue. If the parties agree,
Ms. Karua, one of us is a Seventh-day Adventist, and I'm sure there are some over there. At sunset, we cannot sit.
Well, then with that, I will not, whatever. We will try our best, but kindly be flexible. If one needs 10 minutes to finish, let's have it.
Right, we'll see. We'll see what happens. We have to make some sacrifices. We'll see whether we are able to perhaps shorten the lunch hour or that kind of thing to accommodate our counsel who may require 10 or 15 more minutes.
My Lord. My Lord, thank you for the time.
Just hold on.
Now, Senior Counsel, since you have said the army size, you have caucused amongst yourself, and if we totalize the amount of time that the court has allocated to each of you, it is actually something. Are you in a position now to choose amongst yourself who is going to lead? Because your issues must be cross-cutting. Who is going to lead to take the most time to make a representation, cutting across the others' submissions, and then the others can have a shorter amount of time to stress whatever point they want to stress. That will be very helpful to both sides.
I hear you, my lady, but it will be difficult at this time because the court is already in session for us to do that. We had agreed, or the counsels in each case will stress the point in their case. We will try to manage.
Okay, thank you. Mr. Ochil, what's the issue?
I wish to indicate that Dr. Jack Mwimali had filed grounds of affirmation, and we'll be requesting the court for at least 5 more minutes to speak to that, so it's not left unheard.
We'll see what happens when we reach you. Thank you.
Thank you, my Lord.
Yeah, let's finish with it's now 9.
My Lord, if I may, this is Professor Migaya Kej. I'm not in court at present, but if I may, there have been responses to the Army chief briefs that we've filed, and we'd appreciate 5 or 10 minutes to respond to them.
Sorry, I didn't hear. We didn't hear what you say.
I am saying that there have been responses to the briefs that we filed.
Yes.
And we are requesting for some time, 5 or 10 minutes, to be able to respond to them.
No, as Amisha, we just required you to file your Amisha brief. And that is the rule as set by the Supreme Court. So we'll consider the brief that you filed. Thank you.
Much obliged.
The Honorable Mr. President, I see our time is actually set at 15 minutes and we had requested for 20 minutes.
Yeah, I know there was a request made for 20 minutes, but just proceed. We will see whether you require any more time or not. Introduce yourself for the record purposes. Let's proceed. It's now 9:15.
My name is Christian Andole. The Honorable Mr. President of the Court of Appeal, my Lord Justice, my ladies and your lordships. Good morning.
Good morning.
To restate my name is Christian Andole for the 76th respondent. And today, the issue that I'll be conversing would be the cross appeal on particularly one issue, whether the president should refund the monies used in the unconstitutional constitutional amendment process. My lords and my ladies, Chinua Achebe in his book, Things Fall Apart, says like this, that a man who calls his kinsmen for a feast does not do so to save them from starving. They all have food in their homes. When we gather together in the moonlit village ground, it is not because of the moon. Everyone can see it in his compound. We come together because it is good for kinsmen to do so. My lords, I invite you to allow me to read the provisions of the Constitution in the Kiswahili language, not because the learned bench cannot comprehend English, but because it is good for the grave digger in Langata. It is good for the shoe shiner in community, and it is good for the pregnant Wanjiku in Pumwani. It is also good for the cattle rustler in Baragoi, and it's very good for the beach boy in Watamu. These are the people. These are the wananchi. Not a person bearing the titles Honorable or His Excellency. Any person bearing the titles Honorable or His Excellency, purporting to be the people, mwananchi, is a sheep, is a wolf in a sheep's skin. And my Lord, a special invitation to this court is this. There has been conflicting submissions on who the promoter of the bill is. On one hand, the Attorney General, in his submissions at paragraph 69, says that the initiative is the BBI initiative, a voluntary alliance of political parties. That is the description. But they come before here, and there have been conflicting narrations of who is the promoter or who is the initiator. To that extent, the exact finding that I'm asking this court to make is this: whether the appellants have approached this court with clean hands to warrant upsetting the decision of the High Court. That is the question. Should you find that the conflicting submissions they've made, then they do not warrant the overturning of the decision of the High Court. My Lord, this shift reminds me still of the words of Chinua Achebe in his book, Things Fall Apart, when he narrates about one character called Okonkwo. And Okonkwo writes like this and says like this: When I hold her hand, she says, don't touch. When I hold her foot, she says, don't touch. But when I hold her waist beads, she pretends not to know. The question is, my lords, that when you hold the waist beads of the appellants and ask them, who is the initiator of this proposed bill? They pretend not to know. That is the finding, my lord, that I want you to make. For my lord, the question is that where the court holds, the question is, my lord, that the principle of constitutionalism would behoove this court to start like this, that expressio unius est exclusio alterius. To what extent am I saying this, my lord? I make reference to our document, a bundle of authorities. The Supreme Court of Rhode Island, in the Constitutional Convention of 1883, found at page 887 of volume 2, stated this to that principle. We are of the opinion that the mode provided in the Constitution for the amendment thereof is the only mode in which it can be constitutionally amended. The ordinary rule is that where power is given to do a thing in a particular way, there the affirmative words marking out the particular way prohibit all other ways by implication, so that the particular way is the only way in which this power can be legally executed. My lords and my ladies, on to my first point, whether this court should order His Excellency President Uhuru Muigai Kenyatta to refund the public monies used in the unconstitutional constitutional process. My lords, on this is a novel issue for the following reasons. No court in Kenya has made a determination on Article 226(5) of the Constitution. In the whole of Africa, South Africa in 2018 is the only democratic country that ordered His Excellency President Jacob Zuma to refund approximately 1 billion shillings used in construction of his house. That was the taxpayers' money. And my lords, the history of the erstwhile Constitution of Kenya, with its 6 provisions on public finance, never provided for a provision akin to Article 226(5). And for that reasons, my lord and my ladies, the High Court's findings and declarations at paragraphs 784 to 785 of their judgment, respectively, were sufficient for an order to make good the loss of public funds. No evidence was needed for that order to be made. No evidence. It is strict liability. No evidence was needed. And if any evidence was needed, it was the evidence in the special knowledge of the appellants. Section 112. He who pays the piper plays the tune. My lords and my ladies, in buttressing this point and these findings and declarations, we rely further on grounds 2, 4, 5, 8, and 9 of the 76th respondent's notice of grounds for affirming the judgment of the High Court, dated 4th June 2021. Additionally, in buttressing these findings and declarations, we further rely on the 76th respondent's affidavit dated 27th June 2021 at paragraphs 7F, 7E, 8, 10, 18, 20, which affidavit has not been controverted by any appellants. My lords, I also invite you to look at the doctrine of public trust that we have talked about in our submissions. The doctrine is anchored in Article 73(1) and Article 1. Article 1 of the Constitution talks and says like this: mamlaka yote makuu ni ya wananchi wa Kenya na wanaweza kutekeleza tu kulingana na katiba hii. Mamlaka ya wananchi katika katiba hii yamepewa idara zifuatazo za serikali. My lords, there is a clear delimitation of who serikali is and who mwananchi is. My lords, I also invite you to look at the erroneous application of Article 35 of the Constitution together with unreasonable and reliance of the affidavit of the Auditor General at paragraphs 47 and 48 of our submissions, pages 47 to 48 of our submissions. And therefore, in conclusion, my lords and my ladies, with such demonstrable disingenuity, should the court fold its hands under the doctrines enunciated here of political ripeness, mootness, political questions, I am afraid that the liberties of Kenyans and inalienable rights of the ordinary mwananchi would be suspended by a thread so slender than the hair strand that held the sword of the imperial King Dionysius over the head of Damocles. Thank you.
Council, do your best to stick to the time.
My Lord, I will request for 5 more minutes. And by introduction, my name is Topwale.
You will have to stick to the time, Council. We really are very, very pressed for time. I wish you could start.
I'll try, my Lord. My Lord, my name is Topwale Sinko for the purpose of the record.
Okwale?
Topwale Sinko. And just before, my Lord, I proceed with my submission, I just want to make a rebuttal on what Senior Counsel Kamau Karori said regarding the interplay of Article 38 vis-a-vis Article 257. My Lord, the argument by the appellants is that the President is entitled to initiate a referendum on the guise that under Article 38, which provides for political rights, the President has a right to champion the cause. And I think Justice Kiage followed that. What really happens when the Parliament is wrong? My Lord, my submission is that there are enough safeguards that provides the President with avenue for lawmaking. And just to cite maybe one, under Article 261, my Lord, the President can actually have the Parliament dissolved if it's not performing its function. And under Article 1.4, the people can actually, my Lord, recall their representative where they are not providing or rather carrying out their mandate. And therefore, that is not a justification to abrogate the President the power to amend laws under Article 257. My Lord, the basis also for Article 257, which gives the ordinary mwananchi the right to amend the Constitution, comes from Article 1. The reading of Article 1, my Lord, and this is actually factored also through the history of the Constitutional Review Commission and the final report. Under Article 61, the Attorney General, my Lords, have considered to the fact that the question of amendment has never been contentious in all history making of in the constitutional history making of Kenya. Therefore, the people of Kenya had a very clear mind that they intend to undo that power that enabled the rock executive parliament to mutilate the Constitution. There was therefore no hard time, my Lord, to try to balance rigidity and flexibility to amend the Constitution. And that it's my submission that the powers that the legislature, the executive, my Lords, enjoy is derived from the Constitution. And when you consider like chapter 18, page 18, sorry, of the Njoya case, Justice Ringera talks about the constituent power being primordial, that over and above the constituent power, my lord, being derived, it is also regional. That has to, it's two-pronged, my lord, that the people are bound by the constitution, but also the constituent power is original. And that actually takes us to a definition that in some instances that the people might not be bound by the constitution. Any interpretation, my lord, therefore, that says that the president is not entitled to initiate amendment of the constitution through popular initiative, my lord, I think will be the correct interpretation in that the people are the sovereign. They are the one who donated and constituted the legislator, the executive, and the executive can only act, my lord, within the limit of the power that the people have donated. If the president, my lord, therefore wants to amend the constitution, and if it's indeed in the interest of the monarchy, the president, my lord, can actually resign and do that in his private capacity as a citizen. And I would direct you, my lord,
Mr. Siko, the point was well made. Please move on to the other one. You have 2 minutes precisely.
And my lord, I'll just direct you to a decision by Justice Nambuye between the Ethics and Anti-Corruption Commission versus County Government of Meru, where it was held that in the regime of the Bill of Rights.
Which decision?
Ethics and Anti-Corruption Commission, my lord,
okay,
versus Think County Government of Meru 2018.
All right.
Justice Nambuye and retired Justice Philip Waki presided over that. And it introduced a dichotomy where you view the state, my lord, as a duty bearer and not the right holder. Therefore, the argument, therefore, that you can actually limit the right of the president to express his political rights for the interest of the local monarchy, my lord, actually survives. My lord, as I conclude, I just want to point out what Dr. Viankolu left in the interest of time on the issue of political question doctrine. And our submission is that in as long as it is the interpretation of this court that the popular initiative is an individual right, then the political question doctrine should not arise. I will direct you, my lord, to abundance of authority, the case of R. vs. Miller, concluded by the Supreme Court of the UK, and also the case of Becker vs. Carr. Justice Brennan, my lord, in that decision, brings out a distinction that whenever power is clearly delineated between each arm of the government, such that when we are arguing about the executive, there's a clear line that their mandate is to do with things to do foreign relations, defense. The argument, therefore, that one has abrogated the power of the other, my lord, should not arise. And also, we provided an article by Professor Louis Henking, arguing that the political question doctrine is actually applicable in America and is an disingenuous legal mechanic to shirk off judicial responsibility. The Superior Court, my lord, has unlimited and original jurisdiction under Article 165 to interpret, my lord, the Constitution, to promote in the interest of the local monarchy, and that power is rightly delegated by the people under Article 1.
Thank you, Mr. Siko. Thank you very much.
Thank you, my lord.
Thank you. Senior Counsel Karua, are you here? Sorry, Hamino, please. Can you take your 30 minutes right now?
With the court's permission, there is a young lady counsel, Caroline Kituko, and
the one who was to appear online, virtually?
She's here now, and she's requesting to be heard first. Her condition does give her to request the court to be heard first.
Before?
Yeah, she thinks too much sitting may affect her condition.
I see.
I would request
Dr. Amino, did you hear what Senior Counsel Karua said about Ms. Kituku, that condition cannot allow her to sit down for long. She would like to make a short presentation. Before you do...
I didn't hear my Lord, but I will wait until.
All right.
Thank you.
Unless you want to do it seated. Do you want to sit down?
No, my Lord, I'm fine standing.
You're fine standing? Yes. Okay. Please introduce yourself for record purposes. And you need, I think 10 minutes would do.
No, my Lord, I represent a main party, the respondent, Muhuri, Muslims for Human Rights, who was the main petitioner in petition E2 of 2021 in the High Court. So we'll be seeking to have 45 minutes.
We were calling you yesterday. We couldn't. You could not connect virtually.
My apologies for that.
We will give you a maximum of 30 minutes. We know you are that was a main petitioner. So go ahead right now.
Thank you, my Lord. So the President of the Court and the Honorable Justices, my name is Caroline Kituku. I appear together with Mr. Muhuyu Mwaniki from Muhuri, the 26th respondent in the IBC appeal. We oppose the appeal, and we have filed grounds of affirmation dated the 23rd of June 2021 that we're seeking the court to affirm the High Court judgment. We have also filed the submissions dated the 23rd of June 2021. My Lord, Muhuri's case seeks to challenge the actions of the IBC to process the BBI bill in violation of the Constitution. Muhuri submits that the actions of the IBC to receive the draft amendment bill, that is a BBI bill, together with the supporting signatures, and to proceed to verify that the initiative was indeed supported by 1 million registered voters, and certify the bill and forward the same to the county assembly. The IBC acted in violation of the Constitution, and in particular, Sections 10, Section 94, Section 82(2), Section 249, as well as Article 257, 4, and 5. We say so because at the time the BBI amendment bill was received by the IBC, IBC could not properly, lawfully, and satisfactorily discharge its mandate under Article 257(4) of the Constitution because it lacked the sufficient legal and regulatory framework to process the draft amendment bill. Therefore, it could not proceed to verify that the bill was indeed supported by 1 million registered voters and certify it as such and forward to the county assemblies. To that extent, therefore, I shall address the court on 3 aspects. The first question is whether or not IBC required a legal framework to guide it undertake its mandate under Article 257, 4, and 5. The second question would be whether or not such a regulatory framework existed as at the date the IBC received the BBI bill. And finally, the question of whether or not the procedures that the IBC used were indeed lawful, to the extent that they could help and guide IBC in the verification and the certification process. Now on to the first question. whether or not the IBC required a legal and regulatory framework. It is a submission that the IBC required a framework to guide it undertake its mandate under Article 254. The High Court agreed with that submission and found that at the time that the IBC received the BBI amendment bill, it required to have a form of a legal and regulatory framework to guide its work. You will find that finding at paragraph 752 of the High Court judgment. We therefore urge the court to affirm that finding for the following reasons. Number one, Article 82(1) of the Constitution mandates Parliament to enact a legislation to provide for the conduct of referenda as well as elections in this country. It is therefore the obligation of Parliament to ensure that there is a law in existence that would seek to guide the processes that are associated with the referenda in this country. My lord, my ladies, there are many authorities from this court and as well as from the Supreme Court that hold that an election is not a one-day event, it's a process. Applying the same reasoning in this matter, we would urge this court to find as much that a referenda is not a one-day event, it's equally a process that starts right at the time a promoter comes up with the idea to amend the Constitution, to the point of collecting signatures, to the point of taking them to IBC, to the point the IBC verifies them, certifies them, takes them to the county assemblies, takes them to Parliament, and eventually to the referendum and the counting and the declaration of the referendum result. It cannot therefore be that the law that IBC seeks to rely on, that only provides on the conduct of the referendum, is the sufficient law. There is no law at all that provides for the verification and certification processes under Article 257(4) of the Constitution. Such a law has not been provided in this court because it does not exist and it is not there. The law that this court was referred to exists in section 49 to 55 of the Elections Act. My lord, my ladies, a careful reading of that law will show that it does not in any of its provisions provide for the procedures on the collection and verification of signatures, on the procedures for certification, and on the procedures that are supposed to be undertaken by IBC insofar as its mandate under Article 257(4) and 5 are concerned. My lord, conscious of all the processes that are required to give effect to the referendum, the Constitution has therefore mandated Parliament to enact the law to regulate those processes. And the reason for this is not difficult to find. It is because each of the processes that are required in the context of a referendum, and in particular, Article 257(4), right from the point of collecting signatures to the declaration of the referendum results, if at all, are important, they are fundamental in a democratic society. It cannot therefore be true that Article 257(4) and 5 is self-executing, as this court was told by the IBC. How does it execute itself? Well, it does not have any procedures or any provisions on how signatures are supposed to be collected, verified, and certified. Having said so, the next thing we need to consider is the mandate that the promoters of a popular initiative have under Article 257(4). The obligation is to deliver the draft bill and the supporting signatures to the IBC in order for the IBC to be able to verify indeed that the draft bill and the proposals therein are supported by 1 million registered voters. The question therefore is, what is the role of the IBC upon receiving the draft bill and the supporting signatures? The High Court, at paragraph 734 of its judgment to 741, set out in detail what the IBC is required to do in order to give effect to the provisions of Article 257(4) and 5. The first thing the court said, which we seek to have this court affirm, is that the IBC must verify that the bill to amend the Constitution through a popular initiative is indeed supported by at least 1 million registered voters. My ladies, it is also mentioned that IBC indeed understood its mandate to that extent very well. To that extent, I therefore refer the court to the record at page 3202 to page 3208.
Yes, continue.
Page 3202 to 3208. The record clearly indicates and provides evidence from the IBC itself. IBC in those pages, especially starting at page 320, came up with what it is calling the budget for signature verification. At page 3203, when it came up with a budget, it funded it to the National Treasury. At page 3203 of the record, we will find a document in form of a letter dated the 16th of December 2020 from the Cabinet Secretary, National Treasury and Planning. Paragraph 2 of that document clearly authorizes IBC to go ahead and spend some 93 million thereabout in the process and in order to undertake verification of signatures following the draft bill and the receipt of the signatures by the promoters of the draft bill, being the Building Bridges Initiative. We read all the way to paragraph 30, page 3205. The IBC itself acknowledges that it has a role to verify that indeed the signatures that have been presented to it are the ones that support the initiative. At page 3206 of the record, you will find a document from the IBC that seeks to make announcement for vacant positions for persons who are going to undertake the verification of signatures work at the IBC. It called members of the public to apply for that job, and it listed the criteria that it was seeking from those people. At page 3207, you will find a tweet from the Twitter handle from the IBC that informs members of the public that indeed IBC has started its verification processes of the signatures that it received in support of the BBI bill. Finally, at page 3308, you will find a document that is known as the Administrative Procedures for the verification of signatures in support of a constitutional amendment referendum. All around, and all those documents demonstrate one thing, that what the IBC sought to do was to verify the signatures that were submitted to it in support of the draft amendment bill. To that extent, therefore, we submit that for IBC to have been able to do that particular mandate constitutionally, it required some form of a regulatory framework to enable it to undertake that important constitutional obligation. My lord, my ladies, Mr. Ngumbo informed and submitted in this court that Article 257(4) has 3 aspects. He referred to the aspect of the first one being an initiative, the second being verification, and the third being supported by 1 million registered voters. My lord, my lady, we submit that he conveniently and properly sought to misguide the court by omitting the 4th aspect, which is a draft bill that is supported, the draft bill and supporting signatures. It cannot be an initiative without a draft bill and its supporting signatures. A careful reading, or a plain reading actually, of Article 257(4) indicates that a promoter of a popular initiative cannot deliver the draft bill to IBC without the supporting signatures. So what is then the purpose of the supporting signatures? Or rather, put differently, why did the Constitution deem it important that for a promoter who intends to amend the Constitution must collect supporting signatures and have them delivered to IBC and not DCI? What then was the intention behind that provision in the Constitution? Mr. Ngumbo made this court believe that the supporting signatures are not useful at all. In our view, it could not have been the intention of the drafters of the Constitution to have the signature requirement for cosmetic purposes. No. Had the Constitution envisaged that the IBC should use those other unique identifiers, as Mr. Ngumbo told this court, then nothing, my lords and my ladies, would have been easier than the Constitution to say so. To that extent, therefore, I seek to rely on paragraph 12J of the affidavit of Mr. Michael Goa, at paragraph 12J of his affidavit in opposing the petition before the High Court and in support of the IBC case, stated that a signature is just one of the unique identifiers that IBC can use to verify whether or not a supporter of the initiative is a registered voter. He states that IBC has other identifiers which are unique to IBC, such as a surname, for example, an ID number, the sex of the registered voter, the date of birth, and so on. Then the question is, why didn't the Constitution use any of these unique identifiers in order to identify, indeed, that the registered voter is the one who is supporting the initiative? I submit that there was a reason why the Constitution uses signatures, and that reason cannot be overlooked by this court or by the IBC. Mr. Ngumbo further informed this court that by requiring IBC to verify signatures, we are basically requesting the IBC to undertake forensic analysis and work that is a preserve of the DCI. My Lord, my ladies, that summation is incorrect. We say so because Michael Ngoa's affidavit as well, at page 3287, that is paragraph 12K, paragraph 12K, it states that in respect of every registered voter, IBC has a record of all Form A's which contain the signature or thumbprint of a voter, the constituency of that voter, the county that voter comes from, the ward that voters come from, and so on. Therefore, it cannot be that IBC, where it says that it keeps Form A, which has all these details about a voter, including the signature of the thumbprint, can now purport to say that it does not have a means to verify the signatures, whereas it does hold those signatures. The question then is, do we need DCI to undertake a forensic analysis? We submit no. An analogy would be made. Every bank, if you have an account in any bank in this country, the bank has your signature. How does the bank verify that signature without having to undertake a forensic analysis from the DCI, as Mr. Ngumbo makes us want to believe? In addition to that, at page 3217, of the record, you will find a form produced by IBC in opposing Muhuri's petition. The form is titled Form for Collection of Supporters' Details and Signatures. The IBC envisaged and actually did create a format through which a promoter of a popular initiative would use to go out there and collect signatures. What are these signatures for that it intended, and what were they to do with them if they did not have an obligation to verify them upon receiving the signatures? Further, my Lord, I refer you to paragraph 12O of the affidavit of Michael Ngoa, where it states that the responsibility of the IBC after verifying, it states so. It's not our evidence, it is IBC's evidence. The responsibility of the IBC after verifying signatures is to send the verified signatures to the promoters and public for confirmation that indeed they gave their signatures in support. So the question at this point is, did IBC do so? Did IBC at any point verify the signatures? Did it send them back to the public for verification? To answer that question, I refer the court to page 3340. Page 3340 of the record, where you will find a document called Notice of Interim Verified List of BBI Supporters. At paragraph 2 of that notice, the IBC states it undertook data cleaning exercise by removing incomplete records. That is, I'm quoting verbatim, that is, missing signatures, ID numbers and names, duplicates, and those not in the registered voters. What IBC then tells us, the members of the public, it did was to do a cleaning exercise. It undertook a data cleaning exercise as opposed to verifying the signatures. It never came out to provide a list that had proper supporters and their signatures that it had verified. What it did, it used again the unique identifiers in the list that it sought to upload in its website.
Council, you have 5 minutes to go.
Further on that issue, we submit that until now, the position of the IBC on this process is not known. I say so because Mr. Ngumbo told this court that IBC could not verify the signatures, but on further cross-examination or rather questioning by the member of the bench, Justice Honorable Kiage, he stated that IBC verified. The question therefore is, what did IBC do? It is not known, it is unknown, and that's why its actions are not accountable to anyone or any person. Mr. Ngumbo further informed this court that IBC did not have a database of signatures. Indeed, that evidence is also on record, and I refer you to page 3197 of the record, where you will find a letter by the IBC to Muhuri confirming that indeed it did not have a database of signatures. But all this contradicts IBC position, and it does so because it states, first of all, it has a Form A in its custody. The Form A apparently has the signatures of every registered voter. It further goes and informs my client that it does not have a database. So the position until now of the IBC cannot be ascertained, not by this court, not by any other independent person, because whatever it did to do was not accountable and was not in any way verifiable. On that issue again, Mr. Ngumbo gave an analogy to this court. He told this court a few days ago, Kenyans were able to complain to the registrar of political parties that they had been registered without their consent as members of various political parties in this country. Why were Kenyans able to make that public outcry? They were able to do so because the register of political parties maintains a system that is verifiable, simple, transparent, and credible. All that a Kenyan citizen needed to do was to go to e-citizen platform, input their ID number, and have the details of whether or not they're registered as a member of a political party. Can the same process be said of the IBC and in the manner in which it is sought to conduct its mandate under Article 257(4)? We answer no. IBC did not have a simple, accessible, and verifiable process that it could have used in relation to satisfy that indeed the initiative was supported by more than 1 million registered voters. Finally, before I log off, I would like to refer this court to the administrative procedures that apparently the IBC said it used. the IBC, in its own administrative procedures, and those procedures you'll find them at page 3208 to 3216 of the record. It states step by step what it is sought to do and how it is sought to do it. From paragraph J, it states step by step on verification of signatures, getting budgetary allocation, going to verify both the print and the soft copy of the signatures. It states clearly what it was supposed to do, but it did follow its own procedures. It did not. What it did was to do a data cleaning exercise. We therefore urge this court to affirm the High Court findings that the IBC, in the manner in which it carried out its mandate under Article 257(4), violated the Constitution as well as its own procedures that it had developed to assist the court.
Thank you very much, Counsel.
Thank you, my lord, and I will seek, because I could not cover everything that I intended to refer the court to submissions.
Yes,
and I
thank you
believe
very
that
much.
they'll do so. Thank you very much.
Thank you. Senior Hazo Ameno.
Permit me to say good morning, my lord.
Good morning, Dr. Ameno.
Yeah. My lord, may I say I'm very proud and very happy to have the privilege of appearing before your lordships. My lords, before I go on, Justice Musinga, President of the Court of Appeal, we thank you very much for the efforts you have taken to put us in very civilized surroundings. I know what it means to have had to put up such a structure at a very short notice. We remain most grateful to you.
Thank you.
My lords, may I take this opportunity to congratulate my Lady Justice Okwengu. Lady Justice Okwengu, may I say to you, we remain proud of you. I have had the privilege of appearing before you since the days you were a magistrate, a high court judge, and court of appeal. Some of us who have known you for a long time will remain most proud of you, and I convey to you my sincere congratulations and wish you very well. My Lord Justice Tuyot, I equally congratulate you for having been elevated to the Court of Appeal. It was always a pleasure to appear before you when you are High Court judge. I always looked forward to the time I'm going to appear before you, and I was happy with the points you used to raise, questions you used to ask me, to interrogate me, and I look forward to continuing to appear before you. I wish you very well on the bench. My lords, may I say one or two things? The President of the Republic of Kenya, the Honorable Mr. Justice, the Honorable Uhuru Kenyatta, has filed an application, and I'm inviting you very respectfully, my lords, that you do not take note of the application that he has made before you at all. My lord, while he was at Kisumu, he made certain remarks about judges. My lord, he has failed to get 2 judges who were involved in this case in the High Court to be sworn in as Court of Appeal judges. That is Justice Udunga and his colleague who have not been sworn in at all. My lords, when you come to the court, you must come with clean hands. The President has not come to this court with clean hands at all. And I'm humbly urging you that you borrow a leaf from South Africa. You borrow a leaf from India and Pakistan and say to him, no, we shall not hear you. The orders that were made by the Court of Appeal must stand. He has deliberately refused to swear in judges. My lords, it's my humble submission that when you are coming before a court, you cannot despise a judge and at the same time you appear before a judge and you expect that judge to give you orders at all. May I say, my lords, when you appear before your lordships, we come with tremendous humility. We speak politely to you. We praise you. That praising, that humility, and that courtesy that we extend to the court is not for you personally. It's for the good of the entire country of Kenya to get our people to continue to have confidence in the judiciary and in the administration of judges, of justice in our country. And when you have a president who is not obeying court orders, when you have a president who is demeaning judges before the public, this court must stand firm and say to him, no, we shall not hear you. We shall not give you orders at all. Again, I respectfully urge you, you borrow a leaf from India. You borrow a leaf from Pakistan. You borrow a leaf from South Africa. Decline respectfully and say to him, we shall not hear you, and whatever complaints you have, raise those complaints before another court, but not this court at all. My lords, the 2010 Constitution, perhaps before I go on with that, I have made a list, my lords, which I may give me I have made a list of some authorities or some books I have, which I know that your lordship may not be having them. And I would be prepared to list them to the court through the registrar if that is good. My lords, I have included them in a list of authorities here. If you may permit me to hand them to you.
But be mindful about your time, eh?
No, I know, my lords, as usual, you'll be kind to me.
No, not today, Dr. Haminwa, Senior Counsel. You have precisely 23 minutes now remaining.
Yes. My lords, the books I have are on constitutional amendments by Yaniv Roznai, Constitutional and Political Theory by Ernest Wolfgang, a constitutional judge of Germany, Making Constitutions in Deeply Divided Society by Hannah Lerner, Constitutional Amendments by Richard Albert, and an amendable Constitution by Richard Albert Batel Embra, the Foundations and Constitutions of Constitutional Amendment. There is one book I have not brought to the court, but I'll make it available if the registrar asks me. It's called The Theory of Imperfections. in constitutional making and constitutional amendments.
Yes.
My lords, the Constitution of Kenya 2010 was a response to two things: to the rotten history of this country,
yes,
and to development of international jurisprudence or global jurisprudence. My lords, those of you who are young may not know that this country has a rotten history. This is set out in two books. One is Kenya, A History Since Independence by Professor Charles Hornsby, Professor of International History, I think, at the University in Australia. The other one is Kenya Between Hope and Despair by Daniel Branch. My lords, Condoleezza Rice, who is now, I believe, a professor at Stanford University, when she was security advisor to President George Bush, in her new book that has come out, Democracy, Condoleezza Rice, at page 127, there is only one sentence, my lords, which I would like to read to you. At page 217. On Inauguration Day, that's our President Mike Kibaki, told Kenyans that he was inheriting a country badly ravaged by years of misrule and ineptitude. That was a correct statement. There were assassinations in the country. Pinto, J.M. Kariuki, Tom Mboya, William Ouko, and etc. Many assassinations. People died in suspicious circumstances. Some left the country in exile. People like Ngugi wa Thiong'o, Mazurui, they left the country. There was rampant corruption in the country. My lords, the Constitution, the 20th Constitution, was intended to take care of this. The judiciary was not spared. There was no security for judges at all. Some judges, some judicial officers died under suspicious circumstances. These were things that the new Constitution was supposed to take care of. And my lords, if you read the Constitution very carefully, the way I do, you will find that it does take care of certain things. Certain officers are entrenched. The office of the DPP, the office of the Inspector General, the judiciary, devolution, the preamble, the sovereignty of the people, the leadership code, and etc. My lords, all these things were included in the 2010 Constitution to send a message to Kenyans and the whole world: never again shall we go through this kind of life. Never again shall we go through this. The way the Japanese Constitution has a provisions to the effect that never again shall we have war. The way the Cuban Constitution has a provision, never again shall we go to capitalism. We say to the whole world that never again shall Kenya have this kind of life. And my Lord, this is repeated in the Constitution. If I may refer you to Article 255 of our Constitution, dealing with amendments. 255. My Lords, if you read 255, 256, and I believe, yes, 255, 256, and 257, it emerges very clearly, my Lords, that this Constitution is unamendable. This Constitution is unamendable. And it is not surprising, my Lords, that in one of the books, sorry, my Lords, we are not as organized as we should be when you are appearing before the Court of Appeal. My Lords, if you go through this book I refer to, unconstitutional constitutional amendments, unconstitutional and constitutional amendments, my Lords, if you look at page, this is page 236, my Lords. Page 236 to page 274. 236 to page 274. Yaniv Rosnai, in his thesis for London School of Economics, he has a heading, Explicit Substantive Unamendability of World Constitutions. Explicit Substantive Unamendability of World Constitutions. My Lords, he has set out all the countries that have unamendable war constitutions. And Kenya is one of them. Kenya is one of them. My Lords, Kenya is one of them, and I'll read to you at page 258. Page 258. He has set out very clearly that Kenya is one of the countries that has an amendable constitution. And he quotes articles 255.
Would you kindly speak to the microphone?
Oh, sorry, my Lord. Yeah. Paragraph 255 to Article 257. Paragraph 255, Article 255 to Article 257 as unamendable. And the reason he gives different procedures for different provisions, different procedures for different provisions. Different provisions for different procedures. And indeed, my Lords, when you will look at these articles, when you are writing the judgment, Articles 255, 256, 257, you will find they have different procedures for amendments. When you apply them, it's difficult, impossible, to carry out effective application. It is cumbersome. It is onerous. You cannot actually carry out into practical terms these provisions at all. My Lords, it's my humble submission that one contribution that this court should make to the able judgment that was delivered by our 5 judges, that is Justice Ngugi, Justice Odunga, Justice Teresa Matheka, Justice Mwita, and Justice Jairus Nga, is for you to strengthen that judgment by making a firm finding or a firm order that the Constitution we have now, the 20th Constitution, is unamendable. My lords, that is not wrong. You will be protecting democratic values of the country. To have at the moment a constitution that is unamendable, you are protecting democratic values of the country. There are some people in this country who would like to take us to the old days. We must say to them, no, you will not. We have an unamendable constitution. And an unamendable constitution, there is nothing wrong with that because it is protecting democratic values. My lords, constitutions of the world, whole world, the global kind of development of jurisprudence is towards having constitutions that protect democratic values. And this has been summed up in these 2 books, my lords. My lords, I refer to the books called Constitutions of the World. I believe you must be having a set. There are 4 volumes. They are produced by the Indian jurist M.V. Paile, Constitution of the World. And you find that these constitutions have communality, separation of powers, the role of the judiciary, the role of the executive, the role of parliament, and they have entrenched provisions in all these constitutions. My lord, there was an attack on India about basic structures. May I deal with that? My lord, India has been on the forefront in jurisprudence or international jurisprudence. My lord, you may remember Bangalore principles which were brought about by Chief Justice Bhagwati. India is a member of the Commonwealth. We are members of the Commonwealth. What happens in India, we cannot afford to ignore it. We apply Indian authorities from time to time in our courts, and we cannot say something trying to despise India or trying to show that India is different from us. My lord, with complete respect to my learned friends who said that is completely nonsensical. We ourselves have a lot in common in India. India is, as it were, our sister country. We have a significant population of Indian origin in this country who continue to make a significant contribution to the development of this country. So what happens in India is of considerable importance to us as a country. Now, my lords, if you take the basic doctrine, you'll find that it has spread to many countries. It has spread in Asia. It has spread in Africa. It has spread to Caribbean. It is a part of the global development of global jurisprudence development. It is what you can call part of international jurisprudence. Perhaps I should also add, my lords, that we had a very good meeting also in India of lawyers, including judges, and this book was produced of challenges to the legal profession and investment in developing countries. Again, this was in India. Now, the basic doctrine, my lords, can be taken to be part of the definition of the word amendment, which you will find in the New Oxford English Dictionary. Yeah. And my lords, I've just been advised by Valentine Khaminwa that the word amendment has to be, is in singular, is not in plural at all. My lords, I have filed submissions, written submissions. I hope you have got this book, one that is dated, this one. Which one is this one? Yes, we filed submissions, my lords, on 23rd for Kenya Human Rights Commission. They should be there. We filed submissions, Kituo cha Sheria, on 24th June. They should be there. My lords, may I say this?
In 5 minutes, please.
Yeah, I'll take a short time, my lords. I don't intend to take much more time than that. May I say this, my lords? My learned friends who appeared for the appellant, I listened to them very carefully. And I thought that some of them, whom I happen to know very well, who are great friends of mine, very close to me, and I talked to them from time to time, I got the impression that some of the things that they were submitting to your lordships, they are not things that they really stand for.
They are not what?
Things that they stand for. I happen to know them. Yeah, I thought that they were saying to you things that they themselves don't seem to believe in at all. I happen to know them. Some of them are great friends of mine. I eat with them. I take cups of tea with them. And I know what they stand for. And I thought that when they were addressing your lordships, they were not saying things that they themselves believe in at all. My lord, as a country, we have been unfortunate, very, very unfortunate. We have not had what I can term as selfless politicians at all. The crop of our politicians in this country is very poor. Most of them are job seekers.
The microphone for record purpose.
Most of them are job seekers. They stand absolutely for nothing. And you can see even when they are campaigning, they do not tell anybody what they would do when they come into power. One gets the impression that all that they are doing is looking for a political office. The nearest politician or politician selfless for the years I've been in Kenya, the nearest we have is the late Professor Wangari Maathai. I served him as his advocate. I appeared for him in courts. This was a great lady. She was selfless in many respects. And the other two, I would say, or what the other one I would mention, my Lord, is a self or selfless, is Kenneth Matiba. My Lord, the first crop of politicians who brought us Uhuru in this country were selfless. But after that, the politicians who come into power are tribalists. Most of them are tribalists. They are advancing tribal agenda. My Lord, what they stand for is really to see that they come into power. And the problems they have are their own personal problems. We have to appreciate that the law has got limits, its own limits. Professor Allott tells us so. The Constitution has got limits. That's what we learn from constitutional jurisprudence. And whatever problems we have in this country have absolutely nothing to do with the Constitution. They have nothing to do with the law. They have something to do with ourselves, and particularly the political class. When it comes to violence, they are the ones who are actually, one can suspect, they are really the ones who are fueling this violence. This is set out in the book of
You have a few seconds, Dr. Amino, please.
Yeah, my Lord, may I draw your attention to Interrogating Marginalized Governance by editor Professor George Garner from our university. That is the book I had in mind that I would like to draw your attention to. My Lord, may I say thank you very much.
Thank you.
I argue very respectfully, you throw out the appeal. It has no merit. Absolutely none. The submissions that were made before you were pedestrian submissions. Were not in good faith. Instead, my lords, I'm inviting you respectfully, you uphold the judgment of the High Court and you improve on it.
Thank you. Thank you.
Thank you very much.
Thank you, Senior Counsel. Can we have Senior Counsel Martha Karu? Yes.
May it please the court, I'm Martha Karua, appearing with Muthoni Nyuguto for 3 amici, that is Dr. Ojwang, Duncan Ojwang, Dr. Linda Musumba, and Dr. John Osogo Ambani. I propose to use 20 minutes and seek extension if necessary, and leave 10 minutes to my learned junior, Muthoni Nyuguto. The documents we have filed are written submissions dated the 22nd of June this year with 2 annexures. Digest of authorities dated the 22nd of June this year. Bundle of authorities dated 22nd June this year. All 3 bound in green. 4